Now we move on to the next portion, CERSAI, which is the Central Registry of Securitization, Asset Reconstruction and Security Interest of India, CERSAI. If you remember, when we discussed the legal appraisal of the property, I had made a passing reference to CERSAI, that you can go and check the encumbrance on a particular property through the CERSAI website also. We discussed that in cases of equitable mortgage, there may not be a necessity to register the mortgage. Now again, registration is a state subject, so we will not get into specifics, but there are cases where registration may not be required and it may only be done by way of a deposit of title deeds. So CERSAI is a central portal which is formed by the Government of India, where all the banks, NBFCs, financial institutions and housing finance companies are supposed to go and update the nature of the security interest that they hold on a particular property. Detailed description of the property has to be given, and the nature of security interest that they are holding also has to be updated. So whenever another bank is proposing to give a loan to a particular person, that bank can go to the CERSAI portal and ensure that this property is free from encumbrances. Or if there is any encumbrance, they will come to know of that encumbrance. And the NHB and RBI have also given detailed instructions for updating the information on the CERSAI portal, and updating information on the CERSAI portal is thus mandatory and is not optional. We will now move on to another important act, which is the SARFAESI Act. SARFAESI Act is an act which is meant basically for recovery of the money. Before SARFAESI came into effect, what used to happen is that if a particular loan has gone into default, the only way that the banks or financial institutions had was to follow the process of law and to go to a court and enforce their rights. Now these litigations generally go on for long periods of time, and thus wasting precious time of the bank and also monetary resources. This was not at all fruitful for the banks, and that is why a need was felt to overhaul this recovery system, and SARFAESI Act was brought into effect. Now the role of SARFAESI Act is fourfold. There are four objectives of this act. The first one is securitization of financial assets, which will get covered as a separate module. Reconstruction of financial assets, enforcement of the security interest, and other functions. Now, as far as housing finance companies are concerned, the important aspect over here, apart from the other three, is the enforcement of the security interest. The SARFAESI Act gives banks a time-bound resolution and realization and enforcement of the security. So, if a loan has gone bad, there is a process which is laid down in the SARFAESI Act, which the bank can follow and enforce its security in a time-bound manner. Now, the way it works is that if at all a particular loan has gone bad and it is classified as an NPA, the bank or the financial institution, which is a housing finance company, under section 13 will have to issue a notice, give 60 days time to the debtor to pay the money. So in this notice they'll write that you have availed of a certain loan, this is the amount, as of today the outstanding is this much, we are giving you 60 days time to pay the money, otherwise we will have to take action under the SARFAESI Act. On receipt of this notice, the borrower obviously has a right to object to this. The borrower can raise his objections by saying that this notice is invalid, or if he has some other objections, or if he is not in agreement with the amount that is mentioned, etc. He can raise his objections with the housing finance company within 60 days. So, within 60 days, this objection, if any, has to be sent, and once this objection is received, the housing finance company will have a 15-day time window to ensure that these objections have been addressed. That is, if it agrees with the objection, then be it. If it doesn't, then it has to send a response within 15 days. If the secured debt is not discharged within this 60-day time frame that was given under this notice, under section 13, the creditor, which is the finance company, can enforce the security. Now, what do I mean by enforce the security? That is, this act gives multiple rights to the housing finance company. These rights include taking possession of the property, transferring it, auctioning it, appointing a manager for that property, etc. So, on expiration of this period of 60 days, assuming no objections have been received, they can take the action which is allowed as per the Act. Now, there can be situations where the creditor or the borrower is not happy or is not satisfied with the action that the housing finance company has taken, and he or she feels that there is something which is illegal in this action. In this particular case, that borrower can approach the Debt Recovery Tribunal, the DRT, for ensuring that the DRT gives instructions to the housing finance company to either withdraw the application or to ensure that the process is followed. The DRT process is also time bound. There is a prescribed time limit within which the application has to be disposed of, either in favor of the borrower or against the borrower. This time period can be extended, but again, this time period also cannot be extended in perpetuity. Assuming that the judgment of the DRT comes against the borrower, and the borrower is not happy with the resolution that the DRT has provided, he or she can make an appeal against the DRT order, and this appeal lies to the DRAT, that is a Debt Recovery Appellate Tribunal. DRAT is a authority which is above the DRT. Now, the catch over here is that the borrower cannot indefinitely delay these proceedings by making these frivolous applications and thereby buying more and more time. To ensure that this does not happen, the borrower, when he or she is making the application to the DRAT against the DRT order, has to first deposit 50% of the demand made by the housing finance company, and only then can the application be looked at. This can of course be reduced subject to the procedure which is followed, but in principle the rule remains that a particular percentage of the debt first has to be deposited, and only then will the DRAT hear the application. So if the borrower is simply wanting to buy time, then there will be a cost to buying that time also. So frivolous applications will not be entertained by the DRAT. So as you've seen that this SARFAESI Act provides a speedy resolution, at the same time there is time-bound resolution, and these litigations do not go on for years and years. Even if there is an application which is made to the DRT or to the DRAT, there is a time-bound resolution which will come from both these authorities also. More or less, the implementation of SARFAESI has been smooth.